Meeting called to order at 5:13. Good evening, everyone, and welcome to the March 12, 2026 special meeting of the Richmond Rent Board. Before we begin, if anyone here tonight needs Spanish interpretation, interpretation devices are available at the interpreters section at the front, in the front of the chambers. Please let one of our Rent Board staff members know or the interpreters know, and we will be happy to assist you. Also, as a courtesy to others, we ask that you please silence your cell phones or any other noise-making devices. For individuals who would like to address the board this evening, please be sure to submit a request to speak card to the assistant clerk before the agenda item is announced. This meeting is being interpreted. We ask that anyone addressing the board please speak clearly and slowly to allow for accurate interpretation. Tonight, we will begin the meeting with open session to hear public comments before moving into closed session. The first item on the agenda is roll call. For the purpose of the recording, may I please get an audible roll call from Rent Board members and staff? Board Member Height.
Here.
Board Member Willis.
Here.
Vice Chair Cantor.
Here.
Chair Tipton.
Here.
Interim Executive Director Fred Tran.
Here.
General Counsel Charles Oshanuga.
Here.
For the record, Board Member Espinoza is absent. The next item on the agenda is public comment before closed session. The purpose of open session is for the Rent Board to hear public comments on the following items to be discussed in closed session. The item for discussion under closed session is public employee appointment, Government Code Section 54957B1. Pursuant to Government Code Section 54957B1, the board will meet in closed session to consider the appointment of an executive director. Tonight, we only have one speaker. You will be allowed up to 4 minutes to address the board.
Thank you. So, good evening, Chair Tipton, board members. For the record, I am Cordell Hendler, and I'm a Richmond resident. So, when you go into closed session, I want you to think about Fred Tran for a minute, because he's done an outstanding job so far as the interim executive director, and he has some pretty big shoes that he's been stepping in like in the last month or so. So, when you go back in there, think about all the work that he's done so far. So, that being said, I'll let y'all go back into closed session.
That was the last and only speaker. Since that was the only speaker for closed session, we will now adjourn to closed session in the Shamata room. The open session to hear public comment before closed session is adjourned at 5:17.
All right, we are now ready to begin our scheduled meeting. And the meeting is called to order at 7:02 p.m. Before anything else, I just want to thank everybody for your patience as we were in closed session. Sorry you had to wait so long, and thank you.
All right, good evening, everyone, again. Welcome to the March 12, 2026 special meeting of the Richmond Rent Board. I'm going to announce these, some brief announcements again. Before we begin, if anyone tonight needs Spanish interpretation devices are available at the interpreter section in the front of the chambers. Please let the interpreters know if, and they'll be happy to assist you. Also, as a courtesy to others, we kindly ask that you please silence your cell phones or any other noise-making devices. I also have a few reminders regarding public comments. If you would like to address the board, please submit a request to speak card to the assistant clerk before the agenda item is announced. If you wish to speak on an item not listed on the agenda or on the consent calendar, we don't have one tonight, but on the consent calendar, you may do so under public forum. Please refer to the rent board meeting agenda for the list of agenda items, or to the agenda items open for public comment list, which is posted above the table located in front of the chambers. This meeting is being interpreted, so we ask that anyone addressing the board please speak clearly and slowly to allow for accurate interpretation. The first item on the agenda is the Pledge of Allegiance to the flag. Please join me in Pledge of Allegiance to the flag. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. The next item on the agenda is the roll call. For the purpose of the recording, may I please get an audible roll call from rent board members and staff? Board Member Height,
Here.
Board Member Willis,
Here.
Vice Chair Cantor,
Here.
Chair Tipton,
Here.
Interim Executive Director Fred Tran,
Here.
General Counsel Charles Oshanuga.
Here.
For the record, Board Member Espinoza is absent. The next item on the agenda is a statement of conflict of interest. Are there any? Hearing none, the next item on the agenda is agenda review. Are there any changes to the agenda?
Are there any changes to the agenda from staff?
There are no changes to the agenda.
Are there any changes to the agenda from the board?
Okay, hearing none. Public forum. Okay. Thank you. Hearing none, the next item on the agenda is report from legal counsel of final decisions made in closed session.
General Counsel Oshanuga, could you report on whether any decisions were made in the closed session?
Yes, thank you, Chair. There was a final decision made in closed session. The board has unanimously voted to appoint Fred Tran as the permanent executive director.
Thank you. The next item on the agenda is public forum. Tonight, we have one speaker for public forum. The speaker shall be allowed up to 4 minutes to address the board. When you are called to address the board, stating your name and city of residence is optional. Please terminate your address to the board when your time expires. We ask that you keep your comments respectful and appropriate. The only public forum speaker is Mr. Cordell Hendler.
That's me. So, good evening, Chair Tipton, board members. For the record, I am Cordell Hendler, and I'm a Richmond resident. So, one, I would like to invite the Rent Board to the Richmond Chamber of Commerce's monthly breakfast on March 24th at 8 a.m. at the Courtyard Marriott Hotel. Our speaker for that meeting will be Supervisor John Joyer, who will be sharing with us economic development, housing initiatives, which we're all here for that today, and it's only $25, and that includes breakfast, too. Who knows what they have? But coming up on July 9th, you are all invited to the Contra Costa Mayor's Conference. It's going to be hosted in our neighboring city of San Pablo. More details to come, so you have to RSVP ahead, and the tickets are only $80 a person, and that includes dinner, dessert, and a drink. So I'll get more information by June. And what else? Yes, because I was watching the previous meetings of the Rent Board, and the issues that I have is when we have both parties here, that it was hard for translation they had to like do this, and it's like, and that affects the proceedings. And so it would be great if staff can remind both parties to like slow it down for interpretation, because it's hard for me to like hear the parties without having the interpreters to waive it. So that's all. And then the last thing is that Nicholas Trailer has done a wonderful job with the rent program, and I'm trying not to get emotional again, because after the last meeting, it was hard for, like, for him to like move on as as we got our new executive director, Fred Tran, and I know he will do a wonderful job leading the rent program forward. And speaking of leading, I said I got to lead to my next meeting, so that's it.
That was the only speaker. Okay, the next item on the agenda is item G1 under Rent Board as a whole. Item G1 is to receive a presentation on Regulation 204 and discuss the board's options of exemption compliance as it relates to its existing regulations. There are 9 speakers on this item.
Thank you, and we will now hear the staff report.
Thank you, Chair. It's Charles Oshanuga, General Counsel. You can introduce yourself.
Thank you, Chair. I'm Fred Tran, the Executive Director.
And I'm going to be presenting on the first half, and then Mr. Tran will be presenting on the second half. And I'll try to speak slowly for interpretation, but I will also try to get through the presentation in a reasonable time. So this next slide. So the statement of the issue, just why we're here. I'm sure you all know why we're here. At the last board meeting, we had numerous Monterey Pine tenants come to the board and contend that their units were full of habitability issues, as well as Monterey Pines having a security issue where on more than one occasion, homeless individuals were found in the laundry room. There were also complaints about utility charges. Next slide. So there's no fiscal impact on what we're going to be discussing today. Next slide. So at the last meeting, the board was unable to contend with the tenants' complaints because that wasn't actually the agenda item. At the last meeting, the agenda item was for the board to study the exemption process that it had created. The reason staff brought that agenda item was because in the last few months, we've received an uptick in exemption petitions or applications. And those exemption applications were granted pursuant to our regulations. As a result, we lost around 430 fully controlled units. Those units were converted to partially controlled. That not only has a fiscal impact on the program, it has an impact on the tenants who are residing in those units, and that was not anticipated. And so staff thought it prudent to bring that item before the board at its last meeting. Next slide. Now, coincidentally, at least I did not know that Monterey Pine tenants were facing their own set of issues. And so I think at the last meeting, it kind of got, the two got conflated. The last meeting was just for the board to suspend Regulation 202 so that staff would stop processing applications for exemptions based on governmentally subsidized units, which is different than what the Monterey Pine tenants were asking at the prior meeting. They were asking for a full repeal of all regulations related to exemptions of governmentally subsidized units. Because we could not address that issue at the last meeting, board members contacted staff and requested we place an item to speak about the issues at a special meeting. And so we had to figure out all of the board member schedules, all of our own schedules, and also secure a room. And this is the date we arrived on today. Next slide. So I just want to, my role in this presentation is just to go over high-level Regulation 204. It's in your packet if you want to see the actual regulation, but when the board back in 2018 exempted these units, they also created a regulation that controls when the board is permitted to remove the exemption. And as that conversation was occurring last week, or last meeting, I thought it relevant to bring to the board's attention its powers under Regulation 204. 204 would allow the board to remove an exemption from any property if that property has failed to substantially comply with any applicable provisions of the rent ordinance, the rent board orders, regulations, resolutions, habitability, and Richmond inspection program orders. Next slide. And this next slide just lists some other requirements that you have to comply with, just so the board would know and the public knows. Again, it's all found in the regulation. But the landlord has to substantially comply with what I just previously said, as well as the warranty of habitability. They have to enroll all their rental units, pay the business license tax, comply with Resolution 1901, and comply with any and all requirements set forth in their own regulatory agreement. And what that means is when you are subsidized as a landlord and tenant, the landlord has an agreement with the agency that's subsidizing the rents. That agreement restricts how much rent can be charged. Typically, the agreement would require a certain level of habitability in the unit. Occasionally, the agreement can, but not always, speak to utility charges. Next slide. So, if staff determines that the landlord is not substantially complying with any of the requirements I just mentioned, then staff must, under our regulation, do the following. They first must send a landlord or the landlord a written notice of noncompliance, identifying the issues substantiating its determination of noncompliance, and afford the landlord 60 days to bring themselves into compliance. If after 60 days the landlord has failed to comply, then the next step is for staff to agendize the issue of noncompliance at the next regularly scheduled board meeting. That agenda item is going to be the staff's investigatory report. So that agenda item should include the identity of the property, the steps that staff took to determine that the landlord had failed to comply, the specific findings of noncompliance, and a recommendation of removal. At that meeting, what occurs is essentially a public hearing where the landlord has an opportunity to defend themselves against staff's recommendation. But ultimately, the board, the decision of removal is at the hands of the board at that point. This is a process created to ensure that certain legal rights were maintained by both sides. And I will leave it at that for now. So right now, I'm going to pass it on to Fred.
After the February 18th, 2026 meeting, staff did become aware of the issues, and we do appreciate all the community informing us. We definitely wanted to take action immediately, and staff had contacted the tenants who spoke that provided their contact information. So staff reached out to them and wanted to confirm who they had reached out to, as well as having the right contact information overall. And staff did receive some copies of the letters that were sent out. Ultimately, staff did also reach out to property management because they did enroll with our program. So we'd reached out to a particular staff from Winco who actually had helped out in the prior year when there was a fire at the property, and they actually responded fairly quickly. And with that, they had also informed the owner. Next slide, please. So once the management was involved, staff also sent the board packet information that provided the responses as well as the recording from the prior meeting to assure that the property management could actually listen to all the comments that were expressed. And after that, staff did reach out to the city, contacted the community development department, code and building, as well as the housing authority. And the staff does have an update on some of the inspections that have been conducted. So code and building did start that process as well. They gave us an update, but then there's still some compliance issues that are being covered with code and building. And ultimately, the property manager did provide that information that they received to the owner, who informed their general counsel. And so this week, the general counsel did reach out to the program, and they did send an email after having discussion with our general counsel. And we still are currently doing investigation. But this morning I did send the latest email update that I received from the property manager to community development. And as general counsel has mentioned, the investigation is still ongoing. One other item, we did start drafting a letter. We haven't finalized it, but we're waiting upon board's direction on that.
And if I can just add that the conversation I had with the general counsel, I thought was fruitful. He came across as wanting to address the issue as soon as possible, which is good, which is likely due to the amount of pressure he's received from the tenants and their representatives. They took some issue with the fact that they feel as if we didn't give them enough notice of this particular board meeting. They were concerned that a decision would be made at this meeting and they wouldn't have appropriate representation or voice, because the only individual we've actually spoken to was management and not ownership. They also wanted me to communicate that the general counsel and some high-level representative is flying out to Richmond to meet directly with the tenants in the next 2 weeks. Mr. Tran and myself do not have to wait that long to speak to ownership. I plan to speak with ownership before that, because the investigation is still ongoing, but I don't want it to be delayed for 2 weeks. I don't see any reason why it needs to be delayed for 2 weeks. Okay, but take that as you will. But that's my update. So the investigation is still ongoing. Thank you.
Does that?
Yes, and so the recommendation or recommended action today is just to receive the presentation, as you have already done, related to Regulation 204, and discuss the board's options of exemption compliance as it relates to existing regulations, which really just means feel free to ask us questions about any more details you want us to provide in terms of the investigation and the meaning of the regulation if you need to. Thank you.
Thank you for the presentation. Are there any questions from members of the board? I'm sure we have several. I'll start by just saying thank you to the staff. I think those of us who were here at the last regularly scheduled meeting were all very moved by the public testimony that we heard, and appreciate. I'm heartened to see how much work staff has already done to undertake this investigation, to act with the urgency that it sounds like the situation calls for. I have one initial question, which is, so talking about Monterey Pines in particular, but I guess this is true of any complex. Do the exemptions apply unit by unit or to the complex as a whole? Meaning, or I assume meaning, when we talk about doing the staff investigation and possibly withdrawing exemptions, are we talking about doing all of that unit by unit individually or for the complex as one? Does that make sense?
Yes, it does. So because we have to determine substantial compliance, and because at the time that this was adopted, that board had in mind the entire property, it would be the property as a whole measured against the units that are not in compliance, which goes to the idea of substantial compliance, right? So, if you have a 400-unit building, one unit is not in compliance, the question is that substantial non-compliance versus some other, and it obviously depends on the kind of things that are happening in the unit. You can have just one unit, perhaps. I'm not saying this is a thing, but you can maybe have one unit that it's just so egregious in the unit, the board feels like this is substantially, you're not substantially complying with it. We're just going to remove the entire thing. Also, just one last part of the answer, and you'll hear a lot more about this at our next meeting, the history behind it. But when we were putting this together, there was a lot of outreach to both sides, and part of the idea of the compromise was if we want to have an open dialogue, and we are saying we're not, when you're exempt from rent control, we're saying we're not going to control your rents, but we want to be able to know you're going to comply with certain parts of the law. And your willingness to participate and talk to us is a huge factor in our determination of substantial compliance. If you just stonewall us, that's going to be a problem. So.
I also have a question about sort of precedent. Has Regulation 204 been invoked before? Do we have other properties that have received exemptions and we've used Regulation 204 to withdraw those exemptions?
That's a great question. The answer is no, and you're going to hear a lot next meeting about what it looks like where a subsidized unit is not under rent control. Is under rent control, because there's a lot of questions that need to be answered, and there's a lot of structure that needs to be created to regulate these particular units. And so we're in contact, I think Mr. Tran mentioned, we're in contact with the Housing Authority because we need to first understand how rents are calculated. Depending on the subsidy, if you're just looking at housing choice vouchers, you have two forms of rent. You have the tenant portion, and then you have the landlord, the Housing Authority portion. And so the question is, what portion is regulated and how you figure all that out. And then you have the issue of petitions. If you're in a subsidized unit, doesn't matter if it's LIHTC or housing choice or whatever it may be, those are income qualifying units. So if you received a positive decision through our program with the hearing examiner, and it's a restitution decision, so you're receiving money, that money needs to be reported to the IRS. It's considered income. And yes.
I actually have some insight into that, which is that for purposes of housing with like Section 8 and LIHTC, my understanding is that those are considered assets and not income, so it would not affect eligibility. Any one lump sum distribution is considered an asset and not income.
Okay, so that's not how we historically have interpreted it, but that also brings me to my next point. Some of you might have certain expertise, which is great. And at the next meeting, what we're going to offer or bring before the board is the possibility of creating an ad hoc committee. An ad hoc committee would be comprised of 2 board members who are really passionate or interested about not Monterey Pines specifically, although it would impact Monterey Pines, but with this specific exemption generally, you can have 2 board members who work together with staff, which means you will be included in all of our meetings, in person or in Zoom. You'll be included in the policy drafting. If you want to include yourself in the research, you can. With board member Vice Chair Cantor, which you just mentioned in terms of the asset versus income, that would be something that we would talk about behind closed doors, and we can share our research and drill down on the specific things like that. So for next meeting, but I would encourage you all to think about that. It's a very long answer to say no. It's never been invoked.
I guess as a follow-up question, is that, I should have clarified, I guess there are 2 steps at which it could have been invoked. Certainly we had Monterey Pines residents come forward and advocate for the non-applicability of Regulation 202. So, it's been proactively raised. So I guess one step is, has it ever come before the board that 204 could be invoked? And then the other part of the question is, if it's come before the board, I suppose we could have decided that no, 204 doesn't apply here. I'm assuming from your answer that neither one of those has happened.
That's correct.
Okay. We are open to questions.
Great, I have a question. So apologies, I was in the restroom if I missed this. So looking at this presentation and the timeline, this seems like a fairly lengthy timeline, and I understand the rationale behind it, but it seems like right now staff is in the middle of an investigation and then would need to bring the results of that investigation back to the rent board, and that would, I'm assuming, not be ready by next Wednesday's meeting. Is that correct? So we'd be looking at April at the earliest for the result of the staff investigation, and then after that, after the investigation is completed, and if there is a determination that the landlord isn't substantially complying, then there would be an additional 60 days after that.
So the staff doesn't bring the result of the investigation to the board.
Okay.
Initially. If we determine that there is a substantial non-compliance, we on our own just send a letter to the landlord saying you have 60 days, and we identify all the issues that need to be fixed. If the landlord fixes it, nothing happens. If the landlord fails within 60 days to fix these things, then we do agendize the item before you all and bring the results of the investigation to you all to make the decision.
Okay. So I guess what I'm trying to get at is thinking about, if we move forward with this process as laid out, what the timeline might be for the residents who are here and who have indicated their unacceptable living conditions, to when would they potentially first be able to file a petition with the rent program based on a potential overcharging of rent due to habitability conditions, or when might the exemption actually go into effect if everything moves along? And so, so I guess my first question is, do either of you have a projection of at what point the investigation would conclude, and if a determination is made that the landlord is not substantially complying, that written notice of noncompliance would be sent?
No, because I can't anticipate how, I can't anticipate how soon the owner and I can get into contact, or owner and Mr. Tran can get into contact. I also can't anticipate the outcome of the investigation. I don't want to
No,
predetermine
absolutely.
anything.
Sorry, this is, my question is not about what will happen. It's about sort of what the timelines are. So let me ask it in a more general way then. The determination that the landlord is not substantially complying with any of the requirements, how long does the investigation and determination process, how long would you expect that to take in a general circumstance, not necessarily this one?
If we're only looking at one unit, because here we have multiple units, but if you're only looking at one unit, and it's one landlord, a small landlord, and a tenant, one tenant, so very simple. Not too, I can't give you a specific date, but certainly not too long. I mean, that doesn't seem like,
So-
part of the investigation is, obviously you talk to both sides, but part of it is doing a site visit. And as Mr. Tran mentioned, through the city, have done some site visits to some of these units because they've been inspected. The ones where they haven't inspected, we need to go see them in person.
Okay, so let me, I guess, ask the question a different way. Do you think that it is likely that a staff determination would be made within the next month?
Sure, maybe.
Okay, so let's say 1 to 2 months for that portion, maybe, of just making the determination.
I would be shocked if it's longer than 30 days
Okay.
from today.
Great. So just as an estimate then, just ballpark, no one's promising anything. Then we're looking at mid-April. Then there's the 60 days that the landlord has to bring themselves into compliance. And presumably, on the 60th day, they could say, we did it, we brought ourselves into compliance, and then another investigation would need to be conducted, correct, to determine whether they actually have brought themselves into compliance with regards to habitability issues, because they can say that they have done that, but it doesn't mean that they actually have done it, right? So is there an additional piece there?
Well, if you're cited by the city, the city will come and re-inspect after you fixed all your stuff. So that should be within the 60 days.
So the re-inspection would need to be within the 60 days?
If you're cited by the city, the city will lay out the timeline for you, but typically the timeline is not going to be in excess of 60 days. It would be sooner than that.
Well, so this is saying that if there is a determination of lack of compliance, the landlord would be granted 60 days to bring themselves into compliance. That 60-day period includes passing a new inspection. If in the case of a habitability issue, if the determination by rent program staff is that the landlord is not compliant because of habitability issues, at the end of that 60 days, would that include, basically, like, would everything need to be wrapped up in a bow within 60 days, or would it be the case that on the 60th day, the landlord could send an email saying, we did it, we're in compliance now?
Like, how do we know at the end
How
of
do we
that
know?
60 days that they're compliant?
If it's a habitability issue where there's an inspection, you would know when the city, which is obviously not under our control, re-inspects and says it looks good. And I can't tell you when they do that because they work on their own schedule. Also, one thing is to keep in mind, the standard is substantial compliance. Substantial compliance is not total compliance.
Okay, so I guess maybe what I'm identifying here then is a lack of clarity in this regulation when it says that they're going to be given 60 days to bring themselves into compliance, and then potentially that's interacting with a city process that we don't have any control over of the inspections. There's not clarity about whose responsibility that timeline falls under. And is it the responsibility of the landlord if they're attempting to bring a unit into compliance to make sure that that process is completed within 60 days, or would that 60-day timeline be extended on our end if it seems like, oh, the landlord has made a good faith effort, but the city hasn't done their part within the 60 days?
Yeah, definitely. That goes to substantial compliance. If you are complying and you're saying, hey, I've done all I needed to do, the goal is to get the units habitable.
Yeah.
And, we're not trying to be punitive. So if the landlord says, hey, I've complied, and the city is dragging their feet, I would imagine that in some circumstances that would qualify as substantial compliance. And so staff wouldn't even agendize the item to you all to say, hey, you need to look at this. We would just determine on our own they've substantially complied.
I think what it sounds like, and this makes sense to me as well, is that if we're making it the responsibility of the rent program in the context of Regulation 204 to do an independent investigation and determine noncompliance, then it's very possible it's also going to fall on the rent program to determine compliance. If the city makes that easier on the rent program in that 60-day timeline, great. But if not, there is going to be another piece of this, which is follow-up investigation by the rent program.
I see. Thank you for the clarification. Yes, exactly. So there might be instances where the city does not inspect a unit, right? And so we're not going to have a reinspection. So the staff members would go out. Most likely Mr. Tran would go out and inspect the unit and would be determining compliance and substantial compliance.
Okay. So then to get back to my questions about timeline. So we're looking at mid-April before anything is it would be sent out to a landlord. Again, if pending the results of the investigation. And then they would have 60 days to bring themselves into compliance and alert staff that they have engaged in substantive compliance. And then presumably there is some period after that where staff would conduct where staff may need to conduct an additional investigation to determine whether that the landlord's saying, I've now complied, to determine whether that's true.
Within the 60 days.
That would happen. But if they have 60 days, wouldn't they be able to say on the 60th day, I did it? Or would they have to say within enough time for the rent program to go out and conduct an additional investigation?
Yeah. If they want to wait till the 60th day, as long as we're able to get into the unit and look ourselves on the 60th day.
Okay, that's great. So, so then so then that's 60 days. So then that would be mid-June. So maybe the June rent board meeting would be the earliest possible meeting where the exemption could be heard if everything moves in the direction of an exemption.
Speaking in generalities, not the specific case, 90 days, let's just give it 90 days, 30 for the investigation, 60 for the compliance letter, and then you have to give it likely another 30 to agendize the item, depending on when in the month you land. Because if the compliance, generally, not speaking about this property, but if you determine that a landlord's not in compliance, and you make that determination the day after a regular board meeting, a regularly scheduled board meeting, you're not going to be able to agendize the item until the following month.
Yeah.
So it just depends on the timing. So it could be an additional 30 days after your findings, or it could be the same month of your findings if you found something a week prior to your board meetings. I'm not sure about the timing there.
Okay, so applying that generality to this case, then we'd be looking at 3 to 4 months out before the board would be engaging in any sort of vote. What does the process look like after that? If in a circumstance where staff does an investigation, they determine there's lack of compliance, the landlord does not comply within the 60 days, it gets agendized, the board determines this property is out of compliance, and an exemption, and the exemption should be rescinded. What happens after that?
If you vote to rescind the exemption,
Yes.
it depends. So, not to get into legal issues, but, you know, if there's a lawsuit filed, the exemption is placed on hold. The rescinding of the exemption is placed on hold. The lawsuit would be a writ of mandamus, which is essentially a fancy word to describe you asking the court to have the rent board do what it's supposed to be doing. In other words, the rent board has wronged you. There are some legal theories that you can assert. I don't need to speak about at this meeting, but the writ can take a while. And if you lose on writ, you can be appealed. So it can take a very long time. So if there's a lawsuit, I can't tell you how long. It could be months to years. If there's not a lawsuit, what staff would have to have in place would first be all the things I mentioned. The billing issue too has to be figured out. But once you remove it, 30 days from your vote, the removal is effective.
Okay.
Yeah, I think it's 30 days. I want to say 30 days from the vote. The removal is 30 to 60, but I think 30. Yeah.
Well, and can I confirm, is it the board or staff who awards an exemption in the first place?
It's staff.
Okay, but it would be the board who would vote to withdraw it?
Yes, at staff's recommendation.
Okay.
Yes. And just one, Vice Chair Cantor, I'm not sure if you missed this when I was speaking about substantial compliance. It's just not the unit that needs to be in substantial compliance. It's also one factor out of many is that the landlord has to be communicative with the program. Mm-hmm. So, you know, if you have an unwilling landlord, that's obviously going to weigh heavily in the non-compliance category.
Yeah, absolutely. So I guess just what I'm identifying is that, you know, looking at this regulation in the context of the Monterey Pines complex, the kind of quickest path, the fastest possible resolution of this, again, assuming that everything goes a certain direction, obviously the ideal is the units are all made habitable tomorrow and the investigation doesn't even need to continue. But if it continue, I'm thinking about everybody that's here for public comment and that is experiencing these habitability issues and described these last month and have been living with these for a while. And what this process is offering is no opportunity for relief and for the next 4 months at the absolute earliest. And so I just want to make sure that I'm understanding that correctly, that the process as it's laid out now is not able to be immediately responsive to issues that tenants are facing and is not able to provide any sort of relief in the way that our current petition, because then there's also the petition after that, which we know takes a lot of time.
Yes, this process was created to create a process because there are legal interests at play that require process be created, and the process is important, is what I will say.
Yeah, so I understand that. I'm also, I wasn't here for the last meeting, but you mentioned that the next meeting will have some further discussion about regulations 202 and 204 and potentially with the potential creation of some sort of working group or like subcommittee about that issue. And I am wondering if, and stop me if I'm not like allowed to talk about this now because we're not at that meeting, but if there's any sense of what timeline might be looking like with that, like how, if you have any anticipation of how long that working group would would need to work prior to returning to the board with a recommendation about how to handle those regulations moving forward?
That's a tough question because there's probably about 5 to 6 agencies that need to be coordinated with, and there's a lot of outreach. I can tell you from past experience, when we created the exemptions and these regs, it took about 1 year.
Okay.
And that 1 year was full of meetings. It wasn't a month where there wasn't a meeting. So,
Yeah.
and if I may, going back to your last point about the relief that the regs, I guess the slowness of the relief granted, there is, and I've said it before to lawyers that represent tenants, there are currently relief that lawyers can provide tenants. I'm a government attorney. There's only so much I can do, right? And I don't represent tenants. I don't represent landlords. I represent this agency and the board, and to make sure the board's making decisions that are within the legal bounds. But there's certainly so much law that I've done in my private, when I was not a government attorney, that is still available to each and every single attorney right now, where they could bring lawsuits against landlords. They can stop the landlord from charging rent. Civil Code 1942.5 essentially says if you have an open notice of violation, a landlord cannot collect rent from you. They can't evict you until they fix those things. So there's a lot of pressure points that can really alleviate some of the issues that the occupants are facing.
Okay, great. Yeah, so I just wanted to, ask these questions about timeline so that we can be realistic with those of you who have come out here, that like I looked at some of your comments from the last meeting, have heard some things about it. I understand that there are a lot of issues that need to be addressed immediately. And just wanting to be really clear and realistic that this board, this body, it sounds like there are kind of a couple different paths that things could go, and all of them would take a significant amount of time. And so that's not to say like that nothing can be done, or that that anybody would be like that you all should just wait that amount of time, but just wanting to be really transparent about what the process that we're bound by, and how what you all can expect out of us in terms of getting answers, and what the timeline for that might look like. And yeah, it's there. Things just aren't able to move kind of as quickly as that. This agency and this board is not made to be, is not set up in a way to be immediately responsive to tenant habitability issues. And so I just want to be realistic and transparent about that. And yeah, so I know we have public comment coming up, and want to hear from you all about what you think about it, but just wanted to get that out of the way before public comment. Do you need to go? Okay. Mm-hmm.
And I apologize, I need to excuse myself from the meeting, and Vice Chair Cantor is going to be taking over. Thank you all.
Great. Did you have a question?
Oh, I do.
I'm wondering, we can always hold, the letter I'm looking at from the attorney for MRK, they're claiming that they're going to make resolution for all this, they're going to get hot water back and well, that's just it. I'm wondering, I'm wondering if they're going to be worried that we could rescind 204 within, we could have a special meeting rescinded if these guys didn't start taking action. Does that make sense?
Well, according to what General Counsel Oshanuga was explaining in the presentation, it sounds like that's not something that's within our power to do. Is that correct?
No, you can always rescind any regulation you have. That takes time, but you can do it. And I would have to I'd have to give you all a legal memorandum to tell you all the legal risks involved with doing something like that in this instance, but certainly.
Sorry, are you talking about repealing the regulation or rescinding the exemption?
I'm talking about getting rid of 204.
Can you, microphone?
I'm talking about getting rid of 204 if these guys, if this letter isn't genuine.
Well, so 204 is the mechanism for removing the exemptions. 202 is the one that creates the exemptions. So are you talking about repealing 202?
Both, actually.
Both, okay. Yeah. But you're talking about repealing the entire regulations based on how this
Well,
one...
what I'm talking about, what I'm asking, just what I'm asking, if these guys, if this letter is in bad faith, if we could, it's possible that we could rescind 202 and 204, or do whatever the vehicle it takes to get these guys.
So I guess what I'm understanding from this presentation is that the process for getting a specific building or a specific property carved out and saying you specifically no longer have an exemption is the process that Charles just laid out and that we just discussed and went through the timeline of. The process of repealing those entire regulations, so that wouldn't just affect this property, it would affect every property.
Yeah, no, I understand.
That is, so now it sounds like that is something that it would be possible to take quicker action on.
If you wanted to rescind your regulations that grant exemptions, the board can do whatever it likes to do. There are obviously legal challenges to some of the things it can do. For now, I'll leave it in the public setting. I will leave it at that.
Just as a quick comment, I'll save my feelings and my own personal thoughts about all this until after public comment. But for me personally, outside of just Monterey Pines, which the conditions are horrible, from my perspective, there's so many other properties throughout the city of Richmond that would need the same kind of care and need immediate attention right now and immediate relief. And so when I'm looking at this, and as I talk about this later, I'm thinking about the rest of the city. Monterey Pines is just an example of an ongoing problem that I have been seeing for over 14 years. It's never really gotten better. It happens in little spurts, but problems always seem to arise. And anytime I meet up with tenants again, I always ask them, hey, how are things going since we last talked? More times than not, it's getting worse. So that's how I'm feeling, on top of just even talking about rent control and just cause for eviction and how it passed in general. But I'll pause there because I wanted to go to public comment. But I just wanted to say, outside of Monterey Pines, thinking more globally about a citywide issue too.
Yeah. So I just want to make sure I'm understanding and like getting questions out of the way about what our actual authority is as a board. So I heard from you earlier that you anticipated that if the board were interested in repealing those regulations, it would take a few months to a year to go through that process. But now I'm hearing that it might be that this is something that the board could do at any time that it's on the agenda.
No, I'm sorry if I misspoke.
Okay.
The board, if the board follows its own rules and regulations, to remove an exemption, it's consistent with what I just spoke about. And that process, like you generally can take about, I don't know, I think you said 90 to 120 days, right?
Yeah, I'm asking about the repealing the regulations, not rescinding the exemption, repealing the entire regulations.
If you want to repeal the entire regulations and get rid of all exemptions in the city of Richmond, I'm not sure how long that would take you, but I'm not sure how long that would take you. Would it be a faster vehicle? Maybe in the immediate, but it would likely draw a lawsuit that would tie you up longer than you would want to be.
Okay. So it sounds like then, when we're talking about the options that we have, one option is going through the process laid out in this report. And then the other option that has been floated is repealing those regulations, and that sort of has an unpredictable timeline because the board has the authority to take action on it as soon as it can get agendized, but there might be external parties that have the ability to delay that going into effect.
It would be a pretty serious action that the board would take. That would be a pretty serious action.
Yeah, I understand that. I'm asking about options and timeline to be able to let the community know about what is within our power, not just what would be a measured action, but what is within the bounds of our power as a board.
That's why I'm having difficulty answering the question, because the legal boundaries haven't been explained to you all. And so in a public setting, I can't get into that part of your options.
Okay.
I have to leave it, and that's the best I can explain in public. But obviously, I can speak with you all.
Excuse me, Vice Chair, sorry to interrupt, but we're at the 8 o'clock.
8, so we need to.
So if you want to extend the meeting, we're at the 8 o'clock mark. We're at the 3-hour mark, so we have to vote to extend the meeting.
Great. Can you remind me of the rules? Is it half an hour at a time?
Half an hour because we have the interpreters till 8:30.
Okay. I'd like to make a motion to extend the meeting to 8:30.
Second.
Okay.
Okay, I'll take a quick vote. Board Member Height?
Yes.
Board Member Willis?
Yes.
Vice Chair Cantor?
Yes.
Okay, motion passes with Board Member Espinoza and Chair Tipton absent. We're extending until 8:30.
Okay. I guess let's move into public comment then. Any other questions before? Okay, I'm sure I'll have more after public comment if we still have time.
Okay, as I mentioned, we have 9 speakers to address the board. I will call the first 6 speakers. And as of now, it's 4 minutes to address the board, but however, if they require interpretation, the time is doubled.
Isn't there
If it's 16 or more.
16 or more, and we currently have how many?
9.
Okay, great. Okay.
All right. The first 6 speakers, Teresa Robinson, please come forward. Emily Velez. If I mispronounce your name, please forgive me. Tomika Millhouse. Kathy. I can't pronounce it. Somchith. Varla Perez. and Adam Morton. Just come forward and stand in line until your time. If you require interpretation, just raise your hand. If you have an interpreter, that's fine, but if you need assistance from us, let us know so the interpreter can come and help you. Okay, so Teresa, you have 4 minutes. Oh, it should be like a little button right there on the side. Sorry.
There you go. There we are. Yes.
Great.
Good evening, everybody. As we know, I'm Teresa
Bring it down,
Robinson.
yeah.
I'm from Monterey Pines here in Richmond. Been a Richmond resident for 69 years. That's all of my entire life. What I'm hearing, and I am so sorry, young man, that I have to say this. I hear fear. And we're living in these circumstances. No one else. And I apologize for having to say it like that. But we're worried about suing somebody when we're living beneath our privilege. My money is funny, not my intelligence, not the way that I live, not the way that I treat people. And Monterey Pines owners, I'm not saying the management because they like anybody else that go into their job. They're doing what they're told. But the owners, they know what they're doing. They know what they're not doing. And they know that some people's circumstances are way more uninhabitable than mine. It's not fair. And we can't be afraid. How does changes come if we're scared to speak up? Are we scared somebody they already taking my money? I understand the city of Richmond don't want to be sued, but they're already taking our money. They're raising our rent $300 extra a month. How is that legal? They don't just say it's the rent, but it's the trash, it's the sewer, it's the water, but nevertheless, whatever they're calling it, however they're calling it, it's $300 and some odd dollars coming out of our pocket extra every month. I don't have Section 8. Neither do I have project or whatever it is. Profit-based. I don't have any of that. And I'm a senior, and like I said, I've been in Richmond for 69 years. And you can't be scared, because if we get scared, we get nothing. I give up my time.
Emily Valise.
Good evening, everyone. My name is Emily Velez, and I'm a resident of Monterey Pines. I am here today to call on you to repeal Regulation 202 and 204. Regulations 202 and 204 are allowing the owner of Monterey Pines to get around the rent control law and unfairly increase the rent on myself and my neighbors by $300. All of us are struggling with different issues that add extra stress to our lives. We cannot wait months and months. We deserve to live with dignity. Thank you.
Tamia Millhouse. Excuse me if I mispronounced your name.
That's okay. My name is Tamia Millhouse, and I am a resident of Monterey Pines of 10 years. I personally have a rapport with Sidney Garchek, the owner. 202 and 204, you guys have to repeal this. We can't wait no 3 months, no 6 months, no year. The conditions and what we live in, the high rent on top of the utilities that were complied or quit, that's what we were addressed with. I'm a senior citizen as well, Ms. Teresa, 58 years old. I've worked in the government. I've worked in the school district. But now I had to ask this young lady for food to help me. I think that's unacceptable on top of these conditions that we live. How do you guys expect us to live if we have rent, utilities compiled? I don't want to go back out there and get another job. I will be the worst employee. Sydney needs to do something now, not tomorrow, not next 90 days, but now. She needs to come down here and face us. This is my family. And we are asking you guys, we are pretty much begging you right now to help us. We can't do it. We live with mold, rats, you name it. These units are uninhabitable for anybody to live, let alone us tenants. We work hard. How can you guys raise the rent to the max? Then give us these utilities. We got rent raised in August. And September came, notice to comply or quit. We had 1 month to adjust our finances and to comply. How? How? We had 1 month to do this. In the middle of winter, when it's cold, we didn't have no hot water. We didn't have no heaters. And it was right before Christmas. God have mercy on all of us. But you guys have to do it now. We are begging you as the tenants of Monterey Pines. And please don't wait 3 months. Please don't wait 6 months. We're living in it today.
It's America.
Today. I'm begging you guys. I'm not asking. I'm not pleading. I'm begging. And when Sydney comes down here, she got to face all 322 units that she owns. And how dare her? And how dare you guys not help us? I'm done.
Kathy, how do you pronounce your last name?
Somchit.
Okay.
Good afternoon or good night or good evening, I guess. My name is Kathy Somchit. I've been living in Richmond for 30 years, in Monterey Pines for most of my life. I've seen the good, the bad, the ugly, all of that. We need to take action and repeal regulations 202 and 204, and I know you guys have the power and the ability to help us out. That's all we're asking for. We need your support. Sydney's not listening to us anymore. We feel like we're screaming into the wind. Somebody needs to hear us and help us out now. We don't want to leave Richmond. We don't want to leave our homes. We don't want to leave our communities, our families that we built at Monterey Pines. It's not right to ask us to do that. It's not right to take more money from us than we are able to give. Whatever action you guys can take, please do it. Repeal 202, repeal 204, whatever you need to do it now, because we don't have tomorrow. We may not have next week. We are all here, standing, talking, and fighting, and having you hear our voice. I want to thank you guys for your time. I hope you guys are taking us seriously. Thank you.
Carla Perez? She left? Okay. Then Adam Morton?
Good evening, members of the Rent Board. My name is Adam Morton with the California Center for Movement Legal Services. Many of you I've gotten a chance to meet with. Yeah, I don't think I could say it any better than the tenants have. Frankly, I just don't think this measure is good enough. It's not fast enough. As long as this exemption exists, other landlords will exploit it. I think a really important point is the fact that, even though, 204 has existed for however long, it's never been used. But I think everybody in this room knows there's no chance that it shouldn't have been used before, right? There are absolutely other units where 204 should have been used, and it never has been. So what does that tell you? It tells you it's not good enough. Now, again, as I've mentioned to all of you, these exemptions, they never should have existed in the first place. The voters of Richmond never intended to have them. They were made by a previous rent board. I know it wasn't you, but I don't think it takes an ad hoc committee 6 months to see that these are illegal and they need to be repealed now. And with that, I yield my time. Thank you.
The next three speakers are Leah Simon Weisberg, Juan Carlos, and Jessica Lopez. Please come forward.
Good evening, and thank you so much for serving on the rent board. It is a lot of work, and I know that you don't get paid. I spent 8 years on the Berkeley rent board, and I wrote this ordinance. And when I wrote it, I was very conscious to make sure that low-income tax credits would be covered. Why? Because you don't even have to be a nonprofit to receive this kind of financing. And that this is a statewide problem. I don't know if you know, but Antioch passed rent control 100% because of the LIHTC properties. Because the way that they are structured and the amounts of rents that they can charge, that they're tied to the area median income, which means that the rents can be really high, and they are not tied to the income of the actual tenant. So tenants can be paying 70% of their income. But most importantly, they are owned by private companies. The fact that we know the name of the owner, right? There is nothing, this is not a mission-driven organization. There's nothing that they're providing to the community. If you watch the video, it's a bunch of white people that they want to bring into their properties. They've got 7 seconds of an African-American family. Other than that, they've got a white firefighter, and they have a white nurse, and they own 8 properties across California, and they own a bunch in Florida, and they own some in Missouri and in Michigan. And there is no justification for them not to be covered. Berkeley in the last election covered these same properties. San Pablo and Redwood City both have ballot measures that are going to cover them. More and more cities are doing it. Mountain View covers this. This is not some new rocket science thing. The other thing is, there is more to come, because the only funding coming from the federal government towards affordable housing is this model. And you can, Cal Matters has an article showing that this is actually incredibly expensive, right? They're not paying taxes. They're actually charging quite high rents. They are charging higher rents than they will if these properties had been, they get to raise them higher than if they had stayed rent controlled. So it is, and again, I'm a tenant attorney. I wrote this ordinance. I've written many ordinances. I was on the rent board for 8 years where we actually changed this. I've never heard that it takes 6 months to do this. I think it's very troubling that you're being told if you do this, that you will get sued. Frankly, it is an illegal ordinance. I mean, I teach at a law school, and I literally had my students analyze, would it be a taking if this regulation, your regulations, were erased? And they were like, no, and they sat there and in 20 minutes came up with all of the legal analysis for why. Because with land use, no landlord, and there's, a case that just came from the Ninth Circuit that says a landlord it's a highly regulated field, and they don't get to expect that they're not going to be regulated. Are they going to, landlords threaten to sue all the time for all kinds of things, but they normally don't when they know they will lose. But regardless, this is just wrong, and it's only going to get worse. It's this property, and there's many, many properties. And also to the comment, I want to also say that the reason we passed rent control is because there was a building in this city that had terrible conditions. We came to city council, and we said, you need to do something. And the city attorney sat there and scolded the legal services attorneys in the audience. Can I have?
You can finish your sentence.
Okay. The city attorney had the audacity to sit and scold the low-paid legal service attorneys, I was one of them, and telling us we should have sued. We are going to sue this property. But you know what? There's 350 units. I don't have the capacity to not only take care of this building on your behalf for like half of what your city attorney gets paid, but also I don't have the capacity to function as your city attorney for the whole city. You need to
I'm so sorry. Your time has expired. Thank you for your comment.
Please get rid of this. And demand that you agendize it for the next meeting. I think it is shameful. And I'm sorry, I'm going over. Thank you.
Thank you.
Juan Carlos.
So just a note for everyone, since this is interpreted, we'll have 8 minutes for this comment.
The microphone is not turning on. Do you have another one? It's not turning on.
You know what, can he get the other one, please sit down? Can you sit down?
Do you want me to sit down?
No, well, either one.
I can sit down.
Okay. Thank you. We'll just use that one, I'm sorry.
Tomemos turnos, poquito a la vez.
Muy buenas noches, señores miembros de la Junta de Alquileres. Mi nombre es Juan Carlos Posada.
Good evening, board members. My name is Juan Carlos Posada,
Y soy un residente de Monterrey Pines desde hace 10 años.
and I've been a resident of Monterey Pines for more than 10 years.
Estoy aquí para pedirles que deroguen lo más pronto posible los reglamentos 202 y 204
And I am requesting that you eliminate the 204 and 202 regulations.
Esto necesita ser tomado con diligencia.
And this needs to be done with diligence.
Necesitamos de su apoyo y su ayuda.
We need your support and your help.
Esto no puede esperar más.
We cannot wait any longer.
Estos reglamentos están permitiendo a los dueños de Monterrey Pines y a muchos otros en la ciudad de Richmond
These regulations are allowing many property owners around the city of Richmond
aumentar los alquileres injustamente y eludir los controles que la ley establece.
to increase our rents unfairly and also not obey the rules that they need to obey for the rent increases.
Recuerdo que hace 5 años en Monterrey Pines
Remember 5 years ago in Monterey Pines,
solíamos pagar los biles separados y la renta.
we would pay our bills separately from our rent.
Luego, hace 5 años ellos dijeron, ahora lo vamos a unificar y lo vamos a pagar todos juntos.
But then they said that they wanted the bills and the rent to be paid all together.
Lo cual significa que todo este tiempo nosotros hemos estado pagando biles.
So, which means that during all of these years, we have not been paying any bills separately.
Entonces, por lo tanto, estos biles sí hemos estado pagándolos.
So, we have been paying these bills all of this time.
En septiembre mi renta fue aumentada alrededor de $100.
My rent was increased in this past September around $100.
Luego vienen y ahora me aumentan $250 de biles.
And now they are increasing my bills to $250.
Y no hay a dónde acudir, la verdad.
And I don't know where to find help, truly.
Mi familia y yo nos sentimos desprotegidos.
My family and I do not feel protected.
Gracias a ACE, quiero tomar el tiempo para agradecerles por su apoyo.
I want to appreciate the support and help from, ¿dijo ASEC?
Sí, de ACES.
Oh, ACES.
Y estamos aquí y una vez más no me queda más que decir que deroguen los reglamentos 202 y 204 cuanto antes.
And I would like to repeat myself and say, please eliminate Regulation 202 and 204. Thank you.
Los dueños de Monterrey Pines Apartments no están cumpliendo la ley.
The property owners of Monterey Pines are not committing to the laws.
Desde noviembre aún estoy sin horno, sin máquina de lavar platos y sin trituradora de basura.
Since this past November, I don't have a garbage disposal, a working oven, ¿y qué dijo más?
El disposal.
Ese ya lo dije, y el horno. Y
La
luego?
máquina de lavar platos.
Oh, and the dishwasher, sorry.
En mi casa tengo 3 inspecciones fallidas de la ciudad donde ellos los apartamentos no las pasaron.
In my unit, there has been 3 inspections done, and none of them have passed.
quiero preguntarles cuántas más necesito tener para que ustedes tomen acción.
And I would like to ask you, board members, how many more inspections need to be a fail for you to consider and take this seriously?
Gracias y buenas noches.
Thank you.
Jessica Lopez.
Buenas noches, mi nombre es Jessica López y también soy residente de Monterey Pine Apartments.
Good evening. My name is, dijo Jessica, ¿qué?
Jessica López.
My name is Jessica Lopez, and I'm also a resident from Monterey Pines.
Quiero pedirles, miembros del Consejo, que por favor desistan de los reglamentos 02 y 04 a la brevedad posible, porque sabemos que ustedes tienen el poder de hacerlo. Ustedes son nuestra voz.
I would also like to ask the board to repeal 202 and 204 because you have the authority, you have the power, you are our voice.
¿Por qué nos estamos dirigiendo a ustedes
And the reason
esta
why
noche?
we are directing ourselves to you tonight,
Y estamos haciéndolo por medio de nuestros compañeros de ACE,
and we're doing it through our friends from ACES.
nos estamos apoyando por medio de ellos porque nosotros también tenemos derecho a una vivienda digna que no nos está proveyendo Monterey Pine.
And we are supporting ourselves with ACES because we are living in Monterey Park in an undignified way. Pines, sorry.
Yo sé que ustedes han escuchado mucho sobre las mismas cosas repetitivas
And I know
que
you have-
tenemos como inquilinos.
And I know you have heard many of the same things from the tenants repeatedly.
Pero es verdad que han estado las rentas excesivas y aparte un punto que les comentaba a mis compañeros,
But it is true that our rents are being increased unfairly. But another point that some of my fellow tenants have also mentioned,
que no solamente hemos estado pagando los biles por todo el tiempo que llevamos viviendo en Monterey Pine,
that it's not only true that we are paying too much rent in Monterey Park or Pines,
sino que Monterey Pine nos ha hecho firmar papeles en donde a ustedes les hace llegar que ellos son los que están pagando esos biles. Está todo marcado del lado de donde Monterey Pine se hace responsable de pagar esos biles, cuando nosotros los hemos estado pagando.
but we have received notices in the mail that we need to be responsible of paying not only our rent, but the bills. But we have seen the notice where Monterey Pines has been paying the bills separately, but they are now forcing us to also pay the bills to them included with our rent.
Monterey Pine tiene también personal
Monterey Pines also has employees
que no nos tratan con respeto.
that do not treat us with respect.
Yo he enviado emails
I have sent them emails
en donde adjunto
where I have attached
a la secretaria, al manager
to the
y a
secretary.
los dueños porque nos proveen el email.
to the secretary, to the managers, to the people, because they provide us with this email address.
Y nos dicen, pon aquí tu queja.
And they say, you can write your claims or what you're claiming here.
Y lo hacemos y no nos responden. Y yo les pedí que por lo menos nos dijeran, oh, muchas gracias, recibimos tu queja.
So we do write to this email address where we express our concerns, our complaints, and I am waiting for their response saying, thank you, we have received your email.
Llevo una semana esperando
I have been waiting now for a week
que vayan y compongan la tina de mi baño donde se sale el agua negra.
to come and fix my bathtub where black water is spilling out from it.
Y nos están haciendo pagar por las aguas negras.
And they are making us pay for that black water, that dirty water.
Entonces, si se supone que estamos pagando por ese servicio debe de funcionar.
So
Y no funciona.
if they are supposedly charging us for the water bill, shouldn't we receive adequate water coming in through the pipes?
Nosotros estamos pidiendo por lo que estamos pagando,
we
a lo
are-
que tenemos derecho.
We are just requesting what we deserve to receive. If we are paying for it, we deserve it.
Varios de nosotros nos sentimos amenazados, amedrentados por una letra de 3 días de desalojo si no pagamos alguno de los biles o la renta.
But we are being threatened because they give us a letter of a 3-day notice if we don't pay the bills and the rent.
Ellos no esperan un solo día por un solo dólar. Nos hacen llegar el mensaje de que estamos atrasados.
They don't even allow 1 day of a late payment because they will let us know that we are late in just 1 day.
Pero sí nos hacen esperar meses por agua caliente,
But they do
por
make us wait.
reparaciones,
They do make us wait for hot water,
por control de insectos, animales, cucarachas, arañas, ratas.
for pest control, spiders, insects, roaches, all of the above.
Mi unidad lleva 4 inspecciones. Voy por la 5ª inspección.
My unit has gone through 4 inspections, about to have the 5th one.
Y yo también me pregunto, ¿cuánto más tenemos que esperar?
And I ask myself, how much longer do we need to wait?
Para que nosotros seamos escuchados también.
So we can be heard as well.
Para nosotros no es fácil también ir a buscar a otro lugar.
And it's not easy for us to go and find another place to live.
Porque es verdad lo que dice aquí nuestro compañero Melvin Willis.
Because it's true what Mr. Melvin Willis was sharing earlier.
No solo es Monterrey Pine.
It's not only Monterey.
Son muchas propiedades.
It's so
Tenemos
many
que pagar
other properties.
por adelantado, primer mes, último mes, la renta. Estamos hablando de más de $10,000 para podernos mover.
In order for us to move anywhere, they want us to pay the first month's rent, the last month's rent, the down payment.
Yo les pregunto a mis compañeros, ¿ustedes tienen $10,000 para moverse y dejar a Monterrey Pine?
If you ask any of my friends behind me if they have around $10,000,
¿Ustedes han dejado de pagar biles o renta?
Have you guys stopped paying your bills or your rent?
Por favor, escúchenos.
Please hear
Desistan
us.
de la 02 y la 04.
Repeal 202 and 204.
Ustedes también son nuestra voz, no
You
solo
are.
representan.
You are our voice. You represent us.
Este equipo que ustedes son de la ciudad.
You are the team of this city.
Lo mismo le dije
And the same
al
thing I said
representante de Monterrey Pine.
to the
No
representative.
solamente eres la voz del dueño de aquí, porque nosotros no podemos hablar con el dueño. Tú estás aquí para hablar por nosotros también.
We are not allowed to,
Y no lo haces.
to speak to the
Solamente
property owner.
vienes con tu arrogancia.
You are here to represent us with your voice, and we are not allowed because of their arrogance.
A decirnos, pues es lo que hay.
Because they only say to us, that's what it is.
Muchísimas gracias por escucharme.
Thank you so much for hearing me.
That was the last speaker, but we are at our 8:30 mark, so what do we do?
Okay. So my understanding is that the interpreters are done with their shift and need to leave. Is that correct?
Are you able to stay? Okay, it's up to
Okay.
you.
So I'd like to make a motion to continue the meeting until 9 p.m. or the end of this item, whichever comes first.
Second.
Okay. All right. I'll take a vote for Board Member Height,
Yes.
Board Member Willis,
Yes.
Vice Chair Cantor.
Yes.
Okay, motion passes to extend the meeting, second extension to 9 o'clock with Board Member Espinoza absent and Chair Tipton absent.
Great. Do we have any more public speakers?
That was the last one.
Okay. Great. So let's see. I want to speak a little bit to the speakers. Thank you so much for coming and sharing with us. I want to assure you that I can only speak for myself, but I know that the same is true of my other board members, that we hear you. We are taking this seriously. I want to reflect back some things that I heard, that this issue with being asked to pay for the utilities separately, that you all used to pay the utilities separately. Then, okay, sorry, I thought I heard someone say that it used to be that they were separate, but that then it was merged and the rent was, okay. Well, regardless, that you all were paying for the utilities as part of your rent, as part of your payment, it was included. And now that they have separated it out, but they haven't reduced your rent, they have added onto it. So, yeah, so just want to be clear that, like, I heard that loud and clear. And that, you know, hearing like something that was said earlier is that there are other legal options to address things, and I'm hearing that, you know, that's not an option when there's this many units, and when there are not, and when none of you have the resources to go out and hire a big fancy lawyer. That's the whole point. And you know, my belief is that this is what that this is the role of government, is to protect the people, and that we should not have a society where the only way to get your needs met is to go through the legal system. That's why we have rent control. That's why we have government. And so my understanding is that right now, because what's on this action is we're receiving a presentation and discussing, we can't direct staff to do anything at this meeting because that would be in violation of the Brown Act. But I also heard that discussion of this issue with an opportunity for staff direction will be on the next rent board meeting next Wednesday.
Not the specific issue, but yes, 202 and 204.
Yes, that discussion of what to do about regulations 202 and 204 will be on the agenda this coming Wednesday, and that it will not just be receiving a presentation and discussing. We will be granted the power as the board to issue direction to staff and to take action. So yeah, I'll let Board Member Willis share.
A lot of this is just going to be my comments and personal feelings. Just know I respect all of you, your personal opinion, and where you're coming from. Now I want to let you know where I'm coming from. Also, thank you, everybody, for speaking today. And it's sad and disappointing that your stories aren't the only one that's happening currently, and it's unacceptable that you have to live in these kind of conditions and wonder whether or not you're going to have housing, or if you're going to be displaced to another community that you're not familiar with. I worked on advocating, organizing, gathering signatures, debating this in public forums to have rent control and just cause for eviction whenever it was in front of City Council, then whenever it turned into a ballot initiative. It was important because we needed stability and to cover the maximum amount of people that we could, pending Costa-Hawkins or other legal obligation federal exemptions that we needed to comply with. But the idea for me, when I was organizing, was cover the maximum amount of units that we could. And since Richmond has passed its own rent control, there have been plenty of other jurisdictions that have passed their rent control laws. Some of them through ballot initiative, others through city ordinances. Antioch was 2023, and as I recall, they intentionally included LIHTC units because even with the affordability component of them, folks were still seeing massive rent increases of $400 to $500. What troubled me the last time we talked about this last week is I didn't know that tenants were denied specific services if they were under one of these exempt properties. And what disturbed me even more is just seeing that there are 430 properties that were fully covered before now applying for exemption under this regulation. Outside of this regulation in general, the legalities could be debated, but one thing I do feel strongly of is that if there are going to be any amendments to what gets covered and what does not get covered, that needs to be an issue that goes to the voters. and it is not our place to dictate that some units don't get covered for X, Y, and Z reasons. So that's how I'm strongly feeling, just re-looking at the ordinance, seeing what other cities have done. And I, after listening to this and listening to the many people that I've talked to over the years, I don't see how these regulations are benefiting the residents of Richmond or the rent program. They seem to be causing more harm than good. And I'm seeing an exploitation of a good faith effort that was taken by this rent board previously and now is being abused to squeeze folks for as much money as they can, or the same sentiment that I've heard each and every single time: if you can't afford it, move to a place where you can. So with that in mind, that is where I'm coming from, and I will make a motion and tell me about the process that we begin the process either today or if it's appropriate at next week's meeting, that my motion is that we repeal Regulation 202 and 204.
So about that motion, my understanding is that we are not allowed to make that motion to take action on that tonight, but that will be a motion that can be made on Wednesday. Is that correct?
Well, yes, under the Brown Act, the agenda does not have that consideration, so that you can only consider what's on the agenda. But at the next meeting, if you want to have that because the next meeting concerns 202 and 204, well, the next meeting is a study session, but it does ask for, it's going to ask for board direction. So at that meeting, you can direct staff to bring. So two ways you can do this. One, the board members themselves can agendize an item if you like. If you get it to us by tomorrow, we can have it on the next meeting. And it could say repeal, however you like to phrase it. If you don't do it like that, then you have to wait till the next meeting to do it.
How is it possible just to, sorry, is it okay?
Please, yeah.
If I got to send an email, I'll send an email, but is it possible for us just to make a motion right now that our next regular scheduled meeting next week, that be one of the options that we consider for regulations 202 and 204 in terms of action items?
Yeah.
Okay. Great. Do you want to make that motion?
Yeah, I make a motion that our next scheduled rent board meeting, which is March 18th, thank you, that within the study session and discussion of regulation 202 and 204, that action items be considered, including the action of repealing regulation 202 and 204.
I'll second, but I'd like to make a friendly amendment that not just that we have the opportunity to consider that action, but that we have the opportunity to make a vote that we have an opportunity to vote to repeal these regulations at the next board meeting.
I think you and I are on the same page over
Great,
so
yeah, just wanted to make sure it was really clear so
clear.
that we don't get, yes, we considered it and that fulfills it. Does that?
I accept that.
Okay. And is that in line with what we're allowed to do?
Yes.
Okay, great. So we got a motion and a second.
I do have a quick not trying to make any work, but do you feel like we should have a closed session that day ahead of time? Because I know you said that there are some opinions that you have, but you want to keep them for like an executive session. Not your words exactly, but that's how I took it.
Yeah.
So, sorry, we have a motion and a second, so I think that we need to take a vote on the motion and the second. Is that correct?
Good. That's fine, yeah.
Sure, but I heard the question, so it's fine.
Yeah, and then we'll return to the question after we take that vote.
Okay, I'm going to take a vote. Board Member Height?
Yes.
Board Member Willis?
Yes.
and Vice Chair Cantor.
Yes.
Motion passes with Board Member Espinoza.
Okay.
And Chair Tipton absent.
Great. So we passed a motion, but we're not done with this item. Now we can return to the question.
Sure. I'll be in contact with the board members concerning that. So it might be like a two-part piece.
All right, thanks so much.
Yeah.
Got it. But just that's a good thing to flag for everyone here, that at the next meeting, there might be a closed session at the beginning, just like there was today, for us to discuss with legal counsel, things that we can't discuss in public. Before everyone leaves, I want to say thank you so much for bringing this to our attention. I didn't know about what LIHTC meant. I didn't know that that these exemptions weren't something that were originally stated on the original ordinance. And hearing from everybody that this is a big issue all across the city, and this isn't something that we would have taken up with this level of urgency if you all hadn't brought it here and shared your stories with us. So thank you very much. All right, any other comments before we end this
The next
meeting?
item on the, I know we're about to.
Sorry.
Oh, okay.
Oh.
No.
Sorry.
Well, we have one more item, which is reports of officers. We don't have any, it's fine.
Yeah, well,
Do we
sorry,
have-
I just wanted to make sure there weren't, because Board Member Height hadn't
I'm
been able to
sorry.
say anything. Did you have any comments on this before we move on? Okay. Great.
Okay, sorry.
Yeah, so.
Any reports of officers? None? Okay.
Okay,
Well,
meeting
hearing
adjourned
none-
at 8:44.
8:44.
Also, congratulations, Fred Tran.
Yes,
Look forward to working with you.
congratulations,
Fred.
Fred.
Thank you.
Congratulations.